Many of you believe that banning assault weapons without a grandfather clause violates the ex post facto clause. Many of you believe that it's a taking. Many of you believe that it's an infringement on the Second Amendment. And this is something that you're probably not going to want to hear. We are in the Fourth Circuit of the federal court system. Virginia is. Now, about a year ago, the Fourth Circuit Court of Appeals addressed a case called Colby versus Hogan. And the Fourth Circuit Court of Appeals found that the ban of assault weapons, which include AR-15s and all the things that people are talking about in Virginia, is not a violation of the Second Amendment. Not if, but when Virginia passes the Senate Bill 16 or some kind of variation like it, when lawyers run to federal court yelling, this is a violation of the Second Amendment, you can't make felons out of people overnight, the district courts, the federal district courts, are bound by the Fourth Circuit's opinions, and they will be bound to rule in favor of how Colby versus Hogan was ruled. We're not going to see the federal courts jump in and issue injunctions because Colby versus Hogan will apply. So when these laws pass, you are going to have to accept the cold, hard reality that if you possess a prohibited firearm after the deadline, then you're going to be a felon. You're going to be deemed a felon under Virginia law. Now, whether sanctuary cities will maybe not enforce those laws, however that is, you're going to be committing a felony in Virginia. And so when these laws change, you're going to have to really think about whether you want to be committing a felony. I've seen the Marbury versus Madison posts where, we don't have to follow repugnant laws. The courts have addressed this. The highest court, other than the Supreme Court of the United States, in our district has addressed this and said that not only are these laws lawful, but they're not in violation of the Second Amendment. And so you have to understand that there's not going to likely be injunctions against these laws, even the ones without grandfather clauses. So you're going to need to be looking at either modifying your weapons or your magazines to be in compliance with the law, or you're going to have to remove them to be in compliance with the law, even if you're in a sanctuary city. Please understand that. Running into court yelling Second Amendment infringement, yelling ex post facto, yelling taking, yelling you can't make felons out of law-abiding citizens, all of that has been tried and all of that has been failed. Now, I will say this. If there's any glimmering light here, there is the case of Warman versus Healy. And Warman versus Healy is a case from Massachusetts that is before the Supreme Court of the United States. Now, the Supreme Court has not accepted cert on Warman versus Healy, but everything is queued up. All the deadlines have passed. If the Supreme Court accepts cert on Warman versus Healy, it is going to definitively answer whether or not citizens of the United States can own AR-15s and high-capacity magazines. If we want to do anything right now, we must show up at these city council meetings. We must convince our leaders to approve sanctuary cities. And by doing that, we can possibly persuade Richmond to back off on some of these rules. Maybe we will, maybe we won't. I hope that helps. My name's Tim Anderson. I will see you next time.
So when these shooting events, these highly publicized events continue to happen, They say, oh, because